Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Minimum Wages Act 1948. In any industry where there is a trade union, the workmen agitate by either by collective bargaining or by the support of the trade unions to get better wages and better life. But in the case of unorganized sectors like agriculture, BD, construction and plantation, they are not organized sector. They don't have such trade unions, so they are being protected by the government with the aim of protection of these laborers. And under unorganized sector, the minimum age act was passed. So we have an article 43 of the constitution securing for the living wage to the laborers in the unorganized sector in the state policy. So minimum wage is secured by this act. So, what is this minimum wage? As such, there is no definition of minimum wage in Minimum Wages Act 1948, but in the wage ladder, the living wage is at the top, fair wage is at the middle, and the minimum wage is at the bottom. Minimum wage is the lowest wage paid to the workman, which is fixed by law. Minimum wage doesn't mean the mere subsistence like food, shelter, and clothing, but also includes the measures for education, medical requirements, and other amenities. So there are the employees who are entitled for the minimum wage are at all times and under all circumstances. So the employee to pay, whether he can pay or pay not pay, is irrelevant. We have two case laws in this. Crown Aluminium Company Limited versus Workman. In this case, the Supreme Court has clearly said that any employer who cannot pay the minimum wage has no right to engage the labor, and he has no justification to run the industry. Whoever are capable, whoever is having potential to pay minimum wages to the laborers can only run the industry. In another case law of PUDR versus Union of India, it's famously known as Asiad case, where the workers are engaged in construction of the in the construction of the stadiums and other amenities required for the spectators. In this case, the Supreme Court held that the payment of even 1 rupee less than the minimum wage amounts to the bonded labor system. So, not even 1 rupee less than the minimum wage should be paid to the workers. Otherwise, it is considered as a bonded labor system. So, how is the fixation and revision of minimum wages is done? Under Section 3 of the Payment of Minimum Wages Act 1948, the government can fix or revise the minimum wages. At the time of fixing minimum wages, different kinds of minimum wages may be fixed, like different scheduled appointment, different classes of work in same scheduled employment, adults, adolescents, children, apprentices, different localities. All these are considered as a basis. And how is the procedure for fixing and raising the minimum wages? Under Section 5 of the Act, there are two methods: committee method and notification method, by which minimum wages are fixed and revised. So, let us look into committee method. Under Section 5, Clause 1, Subclause A, the appropriate government may appoint as many committees and committees as considers necessary. Such committees hold inquiry and advise the government in respect of such fixation or revision as the case may be. The composition of such committees or subcommittees is provided under Section 9 of the Act. In this, the committee is a tripartite committee. In the committee, there shall be representative of the employers and employees in the scheduled employments. Such representation shall be in equal numbers. Both representatives of the employers and the representatives of the employees should be in equal numbers. And independent persons not exceeding 1/3 of the total number of members in such bodies shall also be appointed. So, the chairman of the committee shall be an independent person. So, after fixing these in the equal ratio, the representatives of the employers, representative of the employees, and the independent persons, after considering the advices of the committees, the appropriate government may, by notification in the official gazette, fix or revise the minimum wages, and such wage rates shall come into force after the expiry of the 3 months unless otherwise provided in the notification. So, let us look into notification method. Under Section 5, Clause 1, Subclause B, the appropriate government publishes its proposals for the information of persons likely to be affected in the official gazette. The affected person have to send their opinions and objections within the date specified in the publication. Such date shall not be within 2 months from the date of notification. The representation so received will be considered by the appropriate government. It shall also consult the advisory board for fixing and revising the minimum wages. Under this method, the government shall notify minimum wages in the official gazette and they come into force after the expiry of 3 months unless otherwise provided in the notification. So these are the two methods, the committee method and the notification method for fixing and revising the minimum wages.